So insurance fraud is something that the firm deals with and has dealt with for 30 years. And it is something that insurance companies love to bandy about as a word and use very loosely. It's a scary word, but when it walks into a law firm's office, especially a law firm that deals with insurance companies on a regular basis, I have to see some pretty bad facts before I start actually worrying about insurance fraud. It's a very difficult concept for an insurance company to actually prove. It's just that the messaging in the United States, because of the money and power of insurance companies, is that there's so much insurance fraud out there, and I would say, yeah, by insurance companies. Let's start with one concept of fraud, which is fraudulent inducement. And that has to do with contestability of policies when you're dealing with, for example, life, health, disability, long-term care policies. At the formation of the contract, if you made a misrepresentation on your application in order to get the insurance company to give you the policy, right? That's something that can create contestability. And it gives the insurance company the potential right to get out of the insurance policy. And it may or may not be a fraudulent misrepresentation. It could have been a mistake, but in those circumstances, it's a civil claim that's going to involve whether or not you're going to get the benefits under your insurance policy and whether you're going to be able to keep your insurance policy. Then there is misrepresentation during the claims process as to the circumstances surrounding your loss. Arson is the classic example. Somebody set their own house on fire or their own business on fire, or somebody says that their car was stolen when they know it actually wasn't stolen. Then there's healthcare providers who allegedly bill for patients they never saw, or bill for patient visits that never occurred, in order to induce an insurance company to reimburse them for something that was actually didn't happen. So that would be a classic element of fraud. In the claims process, you are making a claim for insurance benefits and you claim that your 2012 Honda Civic was stolen and it had 10 Armani suits in it. That would be an example of perhaps overstating where what was in the car is worth more than what the car was worth. Those are some of the many areas of where things get dicey. During the claims process, when you're being examined by a lawyer, when you're filling out those claim forms, you're going to have to provide proof of loss to the insurance company. Proof that you suffered a loss of property or some other way that entitles you to get money. And when you do that, they are going to look at that very carefully. And if it doesn't smell right or seems wrong, they may investigate further. They may be suspicious. They may send scary letters and do things like that. They may ask you or your insured, if that's not you or someone else who's in your household or someone in your business, and you're doing this in your business, to come in for what's called an examination under oath, or EUO, where they hire a lawyer to question you with a court reporter there about all the circumstances surrounding the loss, as well as ask for all your financial information, which they are entitled to ask for, in order to verify your claim. And if you don't cooperate, then your claim is going out the window. But it doesn't mean that you, as the insured, whether business or individual, have committed fraud. It means that you probably need to talk to someone who's a lawyer, who knows what they're doing, that knows how to tell you what's going on and what you need to do to protect yourself.